This video is about deposing the plaintiff. Before you sit down and depose the plaintiff, you want to procure everything you can about the plaintiff's background. Start with all their social media posts. If they're set to private, ask that they send you their password information to secure it, or at the very least have them provide you a copy of all their prior posts. This may require court intervention, but you're certainly entitled to it if the information contained on their profiles or on their feed is relevant to their liability and damages issues. Also, procure any prior lawsuits that they've been involved in and secure any statements, depositions, or discovery responses they gave in those lawsuits. That may be in the court record, or you may have to call a counsel that was involved in those matters to procure those records. Also, see if they're related or involved in any websites, either their own, perhaps they have a blog or a personal website, or visit their company website and see what's there. If they have their own companies, procure all their corporate records, which can be obtained through your state's Department of Business records or through other records as well. In other words, you're trying to find everything you can on them. Through a Google search, through a Westlaw search, through background searches. There are companies, by the way, for a small fee will provide you a detailed background search that will include their criminal record, which you want to get a copy of, whether they have a concealed weapons permit, what properties they own, whether they've been involved in litigation, divorces, foreclosures. Depending on your case, one or more of these things may be relevant. And once you've got everything, once you've procured everything you can on the witness through your background search, procure all third-party records. If it's a personal injury case, procure all medical records. If it's a breach of contract case, procure all relevant emails and documents exchanged by the parties. And once you have it all together, create a chronology. You can do this yourself or have your paralegal or legal assistant help you. Pull together and call all the relevant records that you have, put them in chronological order, and then create a chronology where you have a notebook of some sort or some sort of filing system where you have a table of contents of all the relevant documents with a brief explanation or description, and you have the documents in order. This will be very important when you're preparing for the plaintiff's deposition. Some of these, if not all of these documents, will become part of your chronology and will be used as exhibits when you depose the witness. So procure the documents, organize the documents, and the next and final step is to prepare an outline. Think of through all the topics you want to discuss with the plaintiff, all the admissions you want to secure, the themes and theory of your case, the documents you want to show the witness to confirm certain information or get him or her to procure or provide certain admissions, and then go through the common stuff, their background, their education, their experience, go through the issues of liability and damages. What admissions can you secure on the liability side, and what issues can you secure on the damages side? And through all this, always keep this through the prism of what you're trying to prove. What are the prima facie case of the various causes of action and the defenses? Remembering that the jury instructions are important to review and study them in order to make sure that you're getting admissions that are relevant, not only for the case at hand, but for the summary judgment and possibly for trial.